Greetings to everyone. Thank you very much for extending the invitation for me to be in your midst this evening, just to minister to you on the subject that is very dear to my heart, the subject of inheritance laws and deceased estates. As introduced, my name is Precious Chakasikwa. I'm a legal practitioner practicing with others in private practice in Harare with the law firm called Country and Imam Legal Practitioners. I've been in private practice since year 2000 when I graduated from the University of Zimbabwe with a law degree. I enjoy sharing legal knowledge, especially in settings such as this, where children of God are coming together and equipping each other with information. As the word says, we are in the world, but we are not of the world. So, because we are in the world, there are issues that affect us, mtemo yenyika, that affect us, that we need to know about in order for us to plan our lives accordingly. So, I feel very honored to be in your midst. Thank you very much. And I'll go into the law as requested. I will try and not use legal terms or legal language because the idea is for all of us to understand. I do hope that you benefit from this small teaching. But if there are questions beyond the allocated time, please feel free to reach out. I'll remain on the group for some time so that I can respond to questions that may come after this session. And if you'd want to approach me privately, maybe with a sensitive issue, feel free to also reach out to me. So, in order for us to unpack and understand the law regarding deceased estates and succession or inheritance, it is important for us to first understand maybe the marital regime, the types of marriages that are recognized in Zimbabwe, and the rights regarding property that attach to each type of marriage, or what we call the marital regime or the proprietary regime. I'll do this very briefly because it helps us understand, or it gives us the background that we need in order to understand now the inheritance laws. As some of you may be aware, we have a Marriages Act, Chapter 515, which was or which came into being in 2022. Before that Marriages Act, we had different Marriages Acts or different acts uh, regarding marriage that were fragmented. Tanga tine mitemo yakasiyana siyana inobata different types of marriage. So you'd need to then look for this particular act. If you are looking at customary marriages, you then need to locate a different statute if you wanted to understand more about civil marriages. So mtemo yedu yanga ingori fragmented all over the place, and parliament saw it fit to consolidate the law regarding or relating to marriage, and that is how the Marriages Act Chapter 515 was born in 2022. Um, so there are three types of marriages that are recognized in terms of this. I'll call it New Marriages Act, but from 2022 to now, it's not really new. But I'll, for purposes of this talk, refer to it as the New Marriages Act. So it recognizes, I would say, three types of marriage. The first type of marriage that is recognized at law is the civil marriage. The civil marriage is what used to be called Chapter 37, and immediately before this new act, it was known as the Marriages Act, Chapter 511. This is a civil marriage. It is what we call at law a monogamous marriage, which is a marriage that only allows one spouse, one man, one wife. This is a monogamous marriage, and it is registered in terms of the Marriages Act. And where a man then enters into another type of relationship or attempts to enter into another type of marriage or to register another type of marriage when they are married in terms of this type of marriage, formerly chapter 37, formerly chapter 511, now a part of the Marriages Act, chapter 515. When someone, a man, then tries to marry or to register another marriage when they are already married in terms of this act or in terms of this type of marriage, they are guilty of the crime of bigamy. They can actually be prosecuted for registering another marriage whilst married in terms of this monogamous type of marriage. So that is marriage type number one that the laws of Zimbabwe recognize. The second type of marriage recognized in terms of the law is the customary marriage. It is formally found in the Customary Marriages Act. Yakatanga kudhara dhara iri chapter 231, then it changed to chapter 507. This type of marriage follows customary rights and tradition, and as such, a man may then elect to have more than one wife. We call this type of marriage a potentially polygamous marriage because it allows for a man to have more than one wife if he chooses to do so. So it follows the customs of the parties wishing to enter into the marriage. These customs must be observed. If it is part of the tradition and customs of the parties to pay rora, then the rora becomes a prerequisite. Whatever chivanhu chinoitwa in terms of the customs and traditions of the parties who are intending to get married, zvinoitwa izvozvo, then the parties come before the authorities and register their marriage as a customary marriage, and it is potentially polygamous. So kune vamwe vane madzimai more than one are registered in terms of this type of marriage, and these are perfectly legal and they are accepted by law as proper and valid marriages. Then the last type of marriage that I want to talk about, that is for some instances or in some instances recognized, but not in every respect, is what is called the unregistered customary law union. In terms of this type of marriage, the traditional marriage ceremonies are observed, such as the payment of lobola or rora. All the rites that are required are done. But this one is then not registered with the authorities. It's just zvinongoperera mumhuri dzedu kuti rora rinongobviswa, munhu otonzi wabhadhara rora rako, you've reached a certain level inofadza the treasurers, and you are then allowed kuti uchitora mudzimai wako mototanga imba as husband and wife. But in the eyes of the law, there is no register where this marriage is registered. This is one of the most common types of marriages in Zimbabwe. And in terms of the New Marriages Act, um, this is recognized as a marriage, although it is unregistered. But there is also a requirement when this new law came into force that gave those who were married in terms of this law but who intended to register their marriages to do so within a period of 3 months from the date yakaunzwa mutemo mutsva uyu. And failure to register did not necessarily affect or does not necessarily affect the validity of this marriage in respect of certain rights. Sezvandataura pekutanga kuti it is recognized for some but not for all purposes. So this unregistered customary law union, it is recognized as a valid marriage when it comes to the status of the parties and also the status of the children who are born from such marriages. Vana vanoberekwa in such marriages are not considered vana vemusango. They are not considered as children born out of wedlock. The law accepts that these are children born in wedlock. So my rights regarding guardianship yevana, custody, and even succession yevana, kuinherita kwevana from their parents, all of that is acceptable. But it's not for other purposes, it is not considered a marriage. So haina divorce inoenderwa kucourt kuti now that this marriage has not worked, we want to dissolve it. Parties cannot go before the law to dissolve such a marriage. uh, how such a marriage is dissolved is also done in terms of customary rights. So these are the three types of marriages that are recognized in terms of the law. I'll then briefly talk about what are now called civil partnerships. I think they were a subject of much debate and discussion when this new Marriages Act uh, uh, um, was passed by Parliament. So before I talk about civil partnerships, I just want to emphasize one thing that this new Marriages Act says. It puts these three marriages that I've just spoken about on an equal footing in terms of importance. There is no one marriage that is considered superior to another. These are marriages that are considered or that are considered equal in terms of the law. So parties then have the liberty to decide which marriage to undertake, depending on what their requirements are, what their preferences are. So civil partnerships, that I'm touching on these very briefly before we get into the real issue yataunganira nhasi yekuti titaura about deceased estates and inheritance laws. Civil partnerships are an introduction of the New Marriages Act. A civil partnership is not a marriage, but it is simply a relationship between a man and a woman that have lived together without being legally married to each other. But from the nature of their relationship, it is apparent that they have the relationship of a couple living together on a genuine domestic basis. So a spouse in a civil marriage, yanambotaura kuti monogamous, chapter 37, chapter 511, one that doesn't allow more than one spouse. A spouse in such a marriage may actually enter into a civil partnership with another woman. What the law does not allow a man married in terms of the civil marriage to do is to register another marriage. But such a man can get into or enter into a civil partnership. I'm not common, well, those that are commonly known as my small house, where there's another woman on the side, there's even another family on the side. These two are not married, but they are living together as a couple or on a genuine domestic basis. The law recognizes that relationship as a civil partnership. And upon the dissolution of that partnership, the law treats that relationship the same way that it treats a marriage when it comes to the division of the assets which these two who are living together in a civil partnership may have acquired during the subsistence of this partnership. So where the spouse to a civil marriage, murume ane mudzimai wake, that he is married to in terms of the civil marriage, chooses to enter into a civil partnership with another woman, or it a small house here on the side. When that civil partnership dissolves, the court can be involved, can be approached to order or to decide on the distribution of the assets that these two acquired in their domestic setup. The law comes in, considers these people to have had a civil partnership, and the same law that applies to a divorce, the same factors that a judge who's dealing with a proper divorce is required to look at or to apply are the same factors that the same court would apply where there's this dissolution of a civil partnership. But I want to emphasize that this is not a marriage. In respect of the topic of the day, deceased estates, a civil partner would not be able to inherit from their deceased civil partner because they did not have a marriage. The law saw it fit to recognize these because, sure, on the ground, the lived realities of people is that these setups exist. Families, children are born in these setups, and there was no law that governed kuti kana vanhu ivava vazosiyana, what happens. And I need to also emphasize that it is not just married men who enter into civil partnerships with other women. Sometimes both parties are unmarried. There are people who decide to come together, to live together as husband and wife, but not actually go into a marital or a marriage relationship. Kutoita vana vototava mhuri dzavo vasina kuroorana. Mutemo wanga usina pawainyatsodzekesa kuti vanhu vakadaro vakazenge vasade kuramba vachigara pamwe chete. How then would their estate or the assets that they will have acquired together, how would they be dealt with? The law was a bit gray on that aspect. So that is why the law saw it fit now to recognize these partnerships and to apply the same rules that apply to a marriage when it is being dissolved to when a civil partnership is being dissolved. I'm bringing this up just to mention it as a type of relationship which does not have the strength of a marriage, which the law now recognizes. And then, in terms of marital regime, I want to basically state this that there are two types of marital regime or that are recognized in terms of the law. We have marriages that are considered to be marriages out of community of property or marriages in community of property. I want to state right from the onset that marriages in Zimbabwe, whether you are going the civil marriage route, the customary marriage route, or the unregistered customary marriage route, really the law says all marriages in Zimbabwe are automatically out of community of property unless the parties prior to their marriage or even during their marriage choose to register a prenuptial contract or a postnuptial contract, bringing their marriage into in community of property. But kana pasina a prenup or a postnup, these marriages are considered automatically out of community of property. I will share briefly on what in community of property means and what out of community of property means. Then we go into the actual inheritance. So when we say a marriage is out of community of property, it means that there is no joint matrimonial estate. It means that each spouse retains sole ownership of the assets that they acquired prior to the marriage, even the property that they acquired during the marriage. As long as the property is registered in their names, that property is considered theirs. So if a property is bought and it is registered in the husband's name, that property remains his. This is despite the fact that the wife may also have contributed towards the purchase of the property, um, or that the property is being used for the benefit of the entire family. And upon divorce of or the dissolution of such a marriage, then the starting point would be that The male spouse is the owner of this property, and during the subsistence of the marriage, the husband can administer this property as he wishes. He can register a mortgage bond over it. He can even sell it during the marriage. Ndofunga munombonzwa nyaya dzekuti pamwe mudzimai anozongoona vanhu vasvika pamba vachitoti takatenga imba iyi, because property inenge ine title deed riri muzita remurume uyu, and because they are married out of community of property, if such a husband were to sell the house without talking, without consulting his wife, and people come and say, we are here to occupy this property, tatenga property, this wife cannot resist such a claim. Anozopedzera uno hake nemurume wake if there are ways in which they can lay a claim. But as far as this property is considered or is concerned, the husband in such a situation can dispose of the property because ndeyake, the parties are married out of community of property. Marriage out of community of property also means that the spouses are not liable for the debts of each other. Zvikwereti zvababa ndezvababa, zvamai ndezvamai. If creditors come and obtain court orders and want to attach in execution ma-assets ababa, they cannot in the same manner or at the same time attach what belongs to the wife by virtue of them being married. The wife is able to say, no, 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 motikari ndeyangu, siyanai nayo, chikwereti ndechababa hachisi changu, because they are married out of community of property. So the assets are owned separately, allowing each spouse to freely deal with their assets as they please, freely dispose of their assets as they please. Uh, Although zvazvo when it comes to divorce, uh, there are laws then that govern kuti how is such property shared. But during the marriage, a man or a wife who owns an asset has freedom to deal with that property as they wish. It also then means that it's a spouse who owns an asset whilst married to another may actually draw up a will and bequeath that asset to someone else other than their spouse, because ndeyake. Mutemo unogamuchira kuti it's his, he has freedom of testation, he can decide, a husband can award the house yaari kugara nemudzimai wake in a will to mwana or to his parent or to someone else, and the law would accept such a bequest kuti it's valid because the property is his. So this is the default regime or the default system that applies to all marriages in Zimbabwe, unless there is a prenup or a postnup that says otherwise. So that is marriage in out of community of property. Marriage in community of property, where there is a prenup that says so. This system, or under this system, both parties are joint owners of the matrimonial estate. The assets that were acquired before the marriage also form part of this joint estate. Some assets may be excluded from the joint estate. For instance, those assets that are inherited from other estates by the spouses, but zvake zvinenge zviri zvake anopinda nazvo marriage, and like the two become one, sezvinototaurwa neshoko when it comes to their assets. And the consequences of this type of system is that all the property will then belong to both husband and wife in equal shares, and both will share in the profits and in the losses that are attached to those assets. Both parties can administer the property. So it means haitengeseki nemunhu one mumwe asina kubvuma. There has to be consent from both sides for an asset that is owned in community of property to be disposed of, or kana kuri iri like things like mortgage, for a mortgage bond to be registered over such a property. So in some countries like South Africa, this regime applies, but kunoku kwedu kuZimbabwe kunoku, it's only where the parties have chosen, have made a deliberate decision to say we want our marriage to be in community of property. Otherwise, the default position is that marriages are out of community of property. So with community of property, it also then means you share not just not just profits but losses. So chikwere chababa, motikari yamai inogona kutorwa, or and vice versa, nekuti ndezvenyu mese. So I thought that I would give that as background, as it will now help us to understand the deceased estates administration, and basically the inheritance laws. Now, when it comes to deceased estates or inheritance laws, or who gets what in the event of a spouse dying, there are two types of estates that I will touch on. The first one is what we call a testate estate. A testate estate. This is an estate where the deceased has left a will, a valid will. So where there is a valid will yasiwa nemufi, and the will is valid if it complies with the requirements of the Wills Act. There is a statute called the Wills Act that governs how wills are drawn up, different types of wills, and all of that. So, where the document that is left by the deceased complies with the provisions of the Wills Act, and the master accepts it as being in compliance with the Wills Act, it is then considered to be a valid will. And the property of the deceased would then be distributed in terms of the will. There are certain things, obviously, that a will must have, or certain fundamentals that must exist. The major or the most important one being that one cannot draw up a will and distribute an asset that does not belong to them. So if I leave a will and I say, State House, I leave State House to my son, obviously that provision would be invalid at law because I don't own State House, and therefore I have no rights over it, and I cannot pass on rights that I do not have. So as long as the will deals with assets that belong to the deceased, even murume uyo wandataura kuti a man married out of community of property with a house registered in his name, or afa murume anogona kutosiya will where he gives that property not to his wife but to someone else. It can be a member of the family, it can be whoever that person chooses to give it to, because at law there is recognition of what is called freedom of testation, that a person who owns what they own is the freedom to decide whom to give such property to upon their death. So where there is a will, and the will is valid, the law simply says apply the provisions of the will, unless there are issues with validity that are then challenged. Or sometimes people will draw up a will, like I may draw up a will today ndine imba yangu 1, ndobva ndati imba yangu ndoda kuti isiyirwe murume wangu o mwana wangu, then maybe next year mwari vandiitira zvakanaka ndawana mukana acquire another property, but I do not then update my will and then I die, then my will only deal with the property that is mentioned. The other property that I will acquire and then does acquire afterwards is dealt with in terms of intestate succession yandichada kutaura nezvayo next. But testate succession doesn't usually present any problems. Munhu anodhisaidha zvaanoda kuita nezvinhu zvake, anogona kusiyira vana vake nemudzimai wake, anogona kusiyira vahama, anogona kusiyira shamwari yake, vanogona kusiyira anyone else. I mean, I'm sure you've heard of situations kunyanyanyanya kune vechirungu, where munhu anosiya property oti I'm leaving this to the SPCA or to Harare Children's Home or some institution and not their family. Freedom of testation says you can do that. It's up to you what you do with an asset that belonged to you during your lifetime. So where there is a will, it's basically considered to be testate succession. And mtema haupindire zvakanyanya, unongopindira pakungotarisa kuti is this a valid will. Was this person in full control of their faculties when they drew it up? Was there undue influence? Was there no undue influence that was brought to bear on them? If none of that exists, the will decides. Whatever the will says is what will apply. Then the next type of inheritance would then be the intestate succession or intestate inheritance. This is now where the person dies without leaving a will or without leaving a valid will. They may have a will, but it's then struck down as being invalid, as failing to meet the requirements of the Wills Act, or maybe it's invalidated on the basis that the person when they signed or drew up the will were not well, were not in full control of their mental faculties, or maybe they were influenced into drawing it up, whatever the reason may be. As long as there is no valid will, or it could be property that is not in the will, either omitted by mistake or property then acquired after the will was drawn up, this would now go into what is called intestate succession. Now, the rights of the surviving spouse in terms of intestate succession would now depend on the type of marriage. That's why ndambotangira ikoko will now depend on whether they have a civil marriage or they have a customary marriage or unregistered customary union, because ultimately the intestate succession laws on it is spouse centered. It looks at the spouse, and it then looks at what type of a spouse are they. Are you a spouse from a customary marriage? Are you a spouse from not just a customary marriage but a polygamous marriage? Or are you a spouse from a civil marriage? That then becomes important, or becomes a critical issue to consider as the law now unpacks who gets what. Hapana will pana mtemo chiti manch is what now we are so about. As I've said, the proprietary rights of the surviving spouse to an estate that is intestate, where the deceased has not left a will, because ipapo ndo panowanzoita nyaya kashoma kuti pane will paite mutauro. Yes, people may feel unfairly treated and all of that, but the law is very, very clear kuti there's a will, the property belongs to the deceased, so we respect the wishes of the deceased. But pasina will ndopanowanzonetsa, but the law steps in now to regulate or to prescribe and proscribe what happens where the deceased now has died without leaving a will. So sezvandataura, the rights of the surviving spouse to the estate depend on the type of marriage that they had. So where the parties had a civil marriage, iyo yandataura yaya kuti yaimbonzi chapter 5:11 kudhara yenzi chapter 37, iri monogamous iyaya inoti one wife. I've been deliberate to say one wife and not one spouse, because Zimbabwean law does not allow a woman to have more than one spouse, even the potentially polygamous marriages, but it allows a man to have more than one spouse. So Zimbabwe recognizes polygamy, which is one man, more than one wife, but does not recognize polyandry, which is one woman and more than one husband. So ndosaka ndanga ndichiramba ndichiti wife, a man and wife, because that is what the law says. So where the parties at a civil marriage, the monogamous marriage, the law that regulates who gets what is called the Deceased Estates Succession Act, Chapter 602. Deceased Estates Succession Act. To succeed is to inherit. So succession is inheritance. So it's called the Deceased Estates Succession Act. The what that act says is that the house or other domestic premises in which the spouse or surviving spouse, as the case may be, lived immediately before the person's death, and the household goods and effects which immediately before the person's death were used in relation to the house or domestic premises, and a child's share of the residue, which means that if they are one step beside the house and the household goods and effects, if there is anything else that is left after these are removed, that is what is called the residue. Kana paine residue, then we consider, or the law would look at, are the children that the deceased has left. If they are children, then the residue is divided equally amongst the children and this spouse, the surviving spouse. So let me clarify. In terms of the Deceased Estate Succession Act, the surviving spouse to a man or to a spouse who has died, vanga vari married in terms of the civil marriage, that surviving spouse, whether it's the husband or it is the wife, inherits in their name, in their personal capacity as their sole and exclusive property, the house or other domestic premises which they lived in immediately before the person's death, the household goods and effects which immediately before the person's death were used in relation to this house, and if there is a residue, an equal share to the residue with the children, if any. That is what a surviving spouse married in a civil marriage would be entitled to. This spouse can be either the husband or the wife. Whoever survives the other would be entitled to these, regardless yekuti property yanga iri mustarani. In fact, they are inheriting from the deceased spouse. So where there is a property registered jointly, where husband and wife are co-owners of a property, the surviving spouse is inheriting the deceased spouse's share. They already own their 50% share. It is the 50% share belonging to the deceased spouse which the surviving spouse would inherit, which would bring the house into the 100% ownership of this. So I hope kuti tapabata ipapo kuti what does a surviving spouse to an intestate estate who's been married in terms of the civil law, civil marriage, what do they inherit? I want to emphasize that pavana apa patataura kuti anopa residue ndopanopinda vana, and also kuti anowana an equal share nevana. These don't have to be children born from the marriage yevaviri ava. It's all children of the deceased. Even vaya vatinoti vana vemusango. It's a term I don't like, but ndo mataurirwo azvinoitwa handiti. So even where there was a civil partner, akazoita mwana, o pamwe murume uyu anga agara atori nemwe mwana kudhara, kana kuti mudzimai uyu anga aine mwana wake asati apinda muwanano iyi, mwana wemufi mwana wemufi. Haanei nekuti akazvarwa muwanano iyo iyi yanga iripo, hazvinei nekuti akazvarwa muwanano, hazvinei nekuti akazvarwa under what circumstances, mwana wemufi mwana wemufi. So if let's say munhu afa apa is the husband, anga aine civil marriage, vanga vaine dzimba mbiri tombodaro, one house, let's say they had a house in Mount Pleasant kwavanga vachigara as a family, and then maybe they'd bought a flat as an investment mutown. Baba vochifa, dzimba dzese idzitomboti zvakare, the house in Mount Pleasant is in the husband's name, the flat in town is in the husband's name. They have 2 children together, but murume uyu akambenga aita mwana before aroora, maybe totanga aita mwana wake 1 asati aroora. So Deceased Estate Succession Act says the spouse, the surviving spouse, is entitled to the house or other domestic premises which she lived in immediately before the death of the spouse. So anowana in this case, kana anga vachigara kuMount Pleasant together and murume oshaya vachigara kuMount Pleasant ikoko, it is that property yekuMount Pleasant that she is entitled to, because those are the domestic premises where she lived in immediately before the death of the husband. The atora imba yekuMount Pleasant and the household goods and effects that were in that property is her inheritance. The residue in this case now would be the flat in town. Flat in town iyi yakuchishewa manje this surviving spouse, nevana vake vairi, nemwana wamufi uyu anga ari wekunze akanga akaitwa before the marriage. So flat yakushewa nevanhu 4 in equal shares. Mwana sezvandatava kuti mwana whether, and mwana uyu doesn't have to be a minor, they could be 30, they could be whatever age they are at. Mwana anowana share yake semwana yakangoenzana nevamwe vana, regardless of their age, regardless of their financial position, regardless of also how they were born, whether they were born out of this last marriage or they were born prior or they were born in wedlock or out of wedlock. As long as ari mwana wemufi, ava akuchisheyana paresidue iyaya yasara, which in this case is the flat. So in the case of parties married in terms of customary law, vaiva the potentially polygamous marriage or unregistered union, their inheritance rights are governed by the Administration of Estates Act. It's a different piece of legislation that governs these ones now, more particularly Section 68F of the Administration of Estates Act. So what that provision says is that the executor of such an estate, the person appointed by the master to administer such an estate, must endeavor to obtain an agreement of the potential beneficiaries on an inheritance plan. Mtemo unovapa that opportunity. Remember that there is no will. The law says the executor appointed must endeavor to engage the potential beneficiaries and agree on an inheritance plan. But if that fails, if there is no agreement, Sometimes, especially if there's barika involved. Remember, this type of marriage is potentially polygamous. So sometimes it's polygamous, sometimes it's not. But where it is actually polygamous, ndopanowanzoita problem even in getting that inheritance plan. Uh, the different spouses may not be able to come together and agree. So what the law then says is, in the event that an inheritance plan is not achieved, the law now says this: where the deceased is a man, Bari Baba Shire in this instance, where the deceased is a man and there is one surviving spouse and one or more children, the surviving spouse shall get ownership of, or if it is not practical for her to get ownership of, then she shall get a right of use called a usufruct at law, a right of use over the house the spouse lived at the time of the death of the deceased spouse, together with all household goods in that house, which is more or less the same as where the marriage was a civil marriage. And then the spouse would then also then get a share of the remainder of the estate or the residue of the estate, more or less zvakangofanana nekunge panga paine civil marriage. But this is where there is the deceased is a man and there is one spouse and children. But where the deceased is a man but is survived by two or more wives, whether or not there are any surviving children, the law then says the wives should receive one third of the net estate. One third of the net estate is divided between the surviving wives. Remember that two or more wives. One third of that estate is divided amongst the surviving wives. Whether vaviri vatatu vangani, one third ndo iri reserved for the wives. But of that one third, the senior wife gets two shares and the junior wife one share, or each. So if there is more than two wives, this of that one third reserved for wives, the senior wife gets one third of the one third. And then, sorry, let me take that again. Of the one third reserved for the wives, the senior wife gets two shares of that one third. And the junior wife, or each of the junior wives, would then share the one share. The remainder of that estate, which is the two thirds now, would then be shared amongst the children in equal shares. So this one third of the estate and all of that only applies if the person who has died is a man and is survived by two or more wives. In addition to this, the wives, and okay, so this one third and all of that is in respect of the net, is in respect of the residue, the net. So in addition to that, where the wives lived in separate houses, each wife gets ownership, or if that is impractical, a right of use over the house that she lived in. at the time of the death of the husband, together with household goods and effects. Where the wives lived together, kune mamwe mabarika ekuti madzimai aya anenge achitogara pamba imwe chete. Where the wives lived together in one house at the time of the death of their husband, then they get joint ownership of that house. Or if ownership is impractical, they get joint right of use, joint usufruct over the house and the household goods and effects. Let me take that again in simpler terms. If the deceased is the man and is survived by two or more wives, if the wives lived in separate houses, each wife gets the house yaigara. If they lived in the same house, they get joint ownership of that house. Of the net now, tabisa dzimba, 1/3 of the net is reserved for wives. But of that 1/3, the senior wife gets 2 shares and the juniors share the balance. The balance, the 2/3 of the net, is shared equally amongst the children of the deceased. Children again could be children from the wives or children from elsewhere, as long as vari vana vemufi. That is how their property will be looked at dealt with. The inheritance rights of the spouse to a customary marriage where the deceased is the husband. Now let's look at what the law says where the person who has died is the woman or the wife. So the law says where the deceased person was a woman whose husband at the time of death had more than one wife, and she is survived by her husband and one or more children. So here now afapa amudzimai ari pabarika, murume wake asara aine mumwe mudzimai, asi iye afa achisiya murume uyu who has another wife, one or more, achisiya zvakare vana. It says the husband gets 1/3 of her estate and the remainder devolves upon her children in equal shares. Husband gets 1/3, remainder devolves upon children in equal shares. Where the deceased person is not survived by a spouse or children, where the deceased person is not survived by a spouse or children, maybe she was married in terms of customary law, husband ndiye akatanga kushaya akainherita zvaakainherita, there were no children, iye paanochizofawo posara pasina surviving spouse and pasina vana, her estate or his estate devolves upon the surviving parents and siblings in equal shares. Pana murume or spouse asara hapana vana, that estate devolves upon the surviving parents siblings and siblings in equal shares. Situations where the deceased is a man and is survived by one spouse but no children. They may have been in a customary marriage, but there is one spouse and there are no children born of this marriage or surviving these two. So the spouse in such a situation gets ownership or right of use of the house together with all household goods and effects. The spouse also gets half the residue, half the remainder, half the net assets after removing the house and household goods and the household goods and effects. The balance then devolves upon the parents and siblings in equal shares. Pakazinge pasina surviving parents, there are no siblings surviving this person, then the entire estate would devolve upon the surviving spouse. There are also situations where murume anoroora mudzimai wake wekutanga in terms of an unregistered customary union. then marries the second wife, who then chooses or insists on getting that marriage registered as a civil marriage. So kune madzimai maviri. First wife is a customary union wife. Second wife is a civil marriage. The law then downgrades that civil marriage, a junior wife, to a customary marriage. So they are then equalized, if for lack of a better word. They are put on an equal footing, and there's laws relating to inheritance where the marriage is a customary marriage and there's more than one wife remaining apply. So the one third to the wives and the senior wife getting two shares of the one third would then apply in such a situation. The second marriage is downgraded. Zvaitika kakawanda mana maybe I don't know my age is ekudhara, where the men used to come to town kubasa vachisiya mai kumusha vachirima and all of that. Kutauni ikoko bva asangana nemumwe mudzimai wechidiki, pamwe akangwarirawo anoziva mutemo, bva ati inini ndinotoda ring, wotonochata neni, vobva vatonochata voregister 511 or civil marriage. Pakadaro that second marriage is downgraded kuitira kuti first wife akasiyiwa kumusha uyu asashayewo chake. Vanobva vaenzaniswa whichinzi one third madzimai, two shares of the one third to the senior wife. But if it's the other way round, if it is the first marriage which is civil and the second one can't be registered, because if it's registered it becomes bigamy. The second one is an unregistered customary law union where Rora was paid but no registration took place because the law would not have allowed it to be so. That junior wife is not a wife at law, is not recognized for inheritance purposes, because murume yanga katanga choose a monogamous marriage which only recognizes one spouse. So the law will not recognize any other spouse in such a situation. But kana mudzimai uyu junior wife anga akaroorwa uyu zviri customary asina kurecognizwa nemutemo for inheritance, kana anga achichengetwa nemurume uyu ashaya uyu, the law provides for a claim of maintenance from an estate where one is able to prove that they were being maintained by the deceased during the deceased's lifetime. So kana anga ari a kept woman who was being maintained nemurume uyu, anogona kuita claim against this estate for maintenance as a lump sum amount, and depending also on what the estate is comprising of, from that residue panogona kuwanikwa maintenance which the court will direct towards this junior wife. It will be maintenance and not inheritance as a wife, because at law that woman would not be a wife because murume uyu anga aine muchato wecivil marriage pekutanga. So that is how property of a deceased person is dealt with. Um, the type of marriage they had is key, and I'm sure from what I shared, you were able to pick out some provisions that seem unfair, some provisions that are, you're like, why would the law provide for such? Especially that provision that says you inherit the house that you were living in immediately before the husband died. We've had cases in the courts where the property is owned by the husband, pamwe ndoega imba yamunayo and all of that, but due to circumstances the parties are not living together, or the surviving spouse was not living at that house. With now how people are in the diaspora, how people sometimes work away from home. One case I remember is where the wife was a teacher at a boarding school and was staying at work, was staying kuma hostels, kuchikoro, boarding school, away from home. Aiuya kumba weekends sometimes, or half term, or school holidays, but pamwe pesa apa during the term anenge ari kubasa. Murume akabva achishaya pakadaro, and the law or the court held that she wasn't living at their house immediately before her husband died. She was living at work, and therefore she could not inherit that house in her own right. That house was put in the common pool, which was then shared pamwechete nevana. She could not inherit the house as a sole and exclusive property simply because pakashaya murume wake aisagara ipapo iye achigara kubasa. That is definitely unfair, but that's what the law says. So where the estate is an interstate one, there is no will, the law has to take its course. We cannot run away from the provisions of the law. The law is what it is. So the best way to avoid zvese izvi kunzi 1/3 this 1/3 that, share with this one, share with that one, we encourage people to plan their estates, to consider estate planning, and there are many options available for estate planning, which are beyond maybe the subject of the discussion today, but ndopanopinda estate planning papo. Ndoita sei to avoid all of this? I don't want the law to take away from my family and give to this one or that one. Or maybe you even had a child that you, there are instances, it's not encouraged, but it happens, where families fall out. There's unforgiveness sometimes that happens, sadly so, and people are not talking. They've basically vaita kakucheka ukama, like, but kana pasina an estate plan, munhu iyeye waunga uchifunga kuti wakacheka ukama naye anotowana chaanowana as long as they are a beneficiary in terms of the law. There are also situations where marriages fail, marriages go sour, people live separate, but they don't divorce. Vanhu vanotosiyana kwemakore, pamwe muvamwe kutoita move on, kutoroora mumwe munhu kana kutoita vamwe vana. People move on years and years, but the marriage has not been dissolved. Hapana divorce yaitika. Murume uyu asiya, mukadzi aenda kwake, murume aenda kwake, atonotenga zvaatenga, atotenga dzimba pamwe, atotenga motikari, atenga zvaatenga. Pakadaro ofa manje, pasina divorce, the law will say surviving spouse. Doesn't matter whether you were estranged, doesn't matter whether you were not living together. Surviving spouse, if there is no house yaanokwanisa kuwana as the house you were living in immediately before the husband died, you are still going to share with the children the rest of the estate on the basis of being a spouse. Yet you were just a spouse on paper, but there was no longer a marriage to talk about. So we also encourage people to plan their estates, and if the marriage has died, I know divorce sometimes are enough cheap, but if the marriage is completely failed and there is no scope of a reconciliation, zvakanaka to find ways of dissolving it legally, because that person wauri kuti ndakarambana naye akaenda kwaakaenda, musina kudimbura muchato, ndiye achasara achiinherita zvinhu zvese zvawakashandira, nekuti anonzi at law they are a surviving spouse. So maybe that's what I would encourage. Let's get help. Let's get education on estate planning so that we avoid some of these unfair provisions of the law. There are different plans. A will in itself is a plan. Family trusts, registration of companies and putting assets in the names of the company, things like that are options that are available in terms of estate planning. Very briefly, in terms of the actual administration of a deceased estate, if there is a will and the will appoints an executor or administrator of the estate, then the master will endorse that appointment and that person administers the estate. That's for testate. But sometimes it may be a tested estate. There's a will, but the will doesn't appoint an executor. The will just talks about assets. In such a situation, as well as in a situation where there is no will, the law, the Administration of Estates Act provides that the estate is registered with the Master of the High Court. Kune maforms anofiliwa ikoko to have the estate registered. The master convenes a meeting called an edict meeting, to the purpose of which is to appoint an administrator or executor of the estate, where the invitation or the attendees to this meeting are family members or anyone who has an interest in the estate. They could be a creditor, they could be a debtor, they could be a child born out of wedlock, they could be anyone who's able to establish an interest in this estate can attend that meeting, that edict meeting. But the purpose of the edict meeting is to appoint an administrator of the estate, and that administrator, once appointed, then, with the supervision of the Master of the High Court, will then follow what the law says in terms of administration. Chinowanzoitika ndechekuti panoendwa kumeeting iyoyi yeedict meeting, ideally the family should be able to agree whom they want to be appointed. Usually we encourage that the person to be appointed be someone who has the time, because ibasa, who has the time, who is morally upright, who is able to do things right and fairly, and need the energy to do it. They have to be above 18 naturally. So the family ideally should agree. But the law says if there is no agreement, or if there is competition for appointment as an executor of an estate, then the law has a hierarchy of preferences. Who the law favors the surviving spouse to be the executor or administrator of the deceased spouse's estate. Kunze kwekunge surviving spouse asingade aramba zvake, only then would the law consider a child, if there's a child who's above 18, failing a child a parent, failing a parent maybe a sibling of the deceased. Or parties or families can opt for a professional or registered estate administrator or a lawyer to administer the estate. But where they opt for a professional to administer the estate, it comes with costs. A professional estate administrator or a professional or a neutral executor who is appointed because the family has chosen that, or who is appointed because vanhu vatadza kuwirirana zvachose and the surviving spouse haasi kuda, or pane more than one wife. Kazhinji zhinji kwamaster pakangoita more than one wife, or pakangoita vana vazvarwa from different wives or whatever, vanobva vakurumidza kuti appoint someone ari neutral, so that hatiite maproblems. So the neutral executor is usually a professional. The cost then that comes with that is that a professional or a neutral executor is entitled to fees, and these fees are 5% of the gross value of the estate. So if the deceased is left $1 million estate, 5% of that million is what is paid to the administrator or to the executor as fees. There are other costs like the master's fees, which are 4% of the gross value of the estate. Sometimes estate duty becomes payable depending on the size of the estate. So zvinouya at a cost. But ndozvakanakirawo futi estate planning yandamboencouragea iyaya, because ukafa une dzimba this and that zvese zviri muzita rako, you are inviting macharges such as the master's fees of 4%. You are inviting 5% of professional executorship fees. But if you plan your estate in such a way that you remove your assets from your name, from yourself, and put them in an estate planning vehicle, such as a family trust, or you may choose to do it in the form of a company. If you divest yourself completely, everything of yours is in the name of the trust or in the name of a company, paunofa unotonzi watofa usina chaunacho. It's like you died a pauper. there's nothing to your name, and you've saved the estate or your family vanenge vazosara of the 5% to the executor and the 4% to the master in the estate duty, because zvinhu zvasisiri zvemufi zviri in the name of a family trust, which is a juristic person or an artificial person or a legal person, or it's in the name of a company which really doesn't die a natural death, so there can be no estate of a company. So maybe tikazowana hedu mukana rimwe ramazuva tinozotaura about estate planning to run away from all this zvandataura izvi zvekuzoti will, zvekuzoti surviving spouse, this, children, that. You can run away from all of that by planning your estate in such a way that the master doesn't even get involved. There is nothing to inherit, as it were. If you put things in a trust, the trust is a perpetual succession. It outlives vanhu venyama, nekuti iyo haisi yenyama, haife. Unenge wakangotaura izvozvo kuti the beneficiaries will be my children, and maybe nevazukuru nevasati vazvarwa, the children to be born and the grandchildren to come can also be included in a family trust as beneficiaries. And you can attach whatever conditions. Properties are not to be sold. You appoint trustees that you know will be able to administer zvinhu zvemutrust zvakanaka zviri fair in the best interest of everyone. So I think for today, it's been a while, it's been close to 3 hours. I think for today, tomirira pano. I hope and pray that pane chatabatawo 1 or 2 things and kuti tabatsirika. But as I have said, I'm available to take questions. They can come to my inbox if they are of a personal nature, but zvakanakawo futi to share them on the platform so that tinobva tadzidza tese. So I'm available to take your questions beyond now into the evening, into the night, into the tomorrow, whenever pandinokwanisawo kuwana mukana to look at the questions. I will do my best to respond. So once again, thank you to the leadership of this platform for inviting me, Maiwa Shoma. Thank you so much. I have to state this. Ndichitanga basa chibva kuyunivhesiti ndakashanda namai washoma. Tanga tiri malawyer zvedu, but tanga tina chataimboziva about running a practice, and she was one of the people who held my hand and taught me how to run a legal office. So I remain eternally grateful, mai washoma, if you are here. So thank you. Tongotenda mwari vatipa mukana wekuti tingodzidzisana shoma izvozvi. Amen and thank you.
Thank you for listening to Hymns Daily Devotional. Remember to share, like, press the notification button, and subscribe to our channel for more.